Rule 1.16, Withdrawing from representing the client. The rules set forth the responsibilities of the attorney to communicate with the client and comply with the client's directions. However, as we have seen before, the attorney is not permitted to violate the law or commit fraud to aid the client. Accordingly, under Rule 1.16, the attorney is obligated to withdraw if representation will involve the client violating the law or the rules of professional conduct. The attorney is permitted to withdraw if the lawyer reasonably believes that the client's course of action will be criminal or fraudulent, or if the client has already used the attorney's services to perpetrate a crime or fraud. There are other justifications for the lawyer withdrawing short of violating the law or the rules. The lawyer is permitted to withdraw if the client insists on a course of action that the lawyer finds repugnant or with which the lawyer fundamentally disagrees. Thus, while the lawyer is the agent for the client, the lawyer is not enslaved by a client and should cleanly cut off relations when the lawyer is morally opposed to the client's case, rather than twisting the client's arm to behave in the way the lawyer prefers. Rule 1.16a requires the lawyer to withdraw in two other situations. It requires the lawyer to withdraw when the lawyer is discharged. A paying client has the right to discharge the attorney at any time, with or without cause, subject to his liability to pay for the services already rendered. If the attorney has been appointed by the court, the client may not have the right to discharge the attorney. The appointing authority should be notified of the client's dissatisfaction and make that call. The rule also requires the lawyer to withdraw when her physical or mental condition materially impairs her ability to represent the client. Here again, the lawyer is required to withdraw prior to violating the rules of competence or diligence because she has some impairment. Sadly, many lawyers who get into ethical difficulties arrive at that situation because they have drug or alcohol difficulties or they have a mental illness, such as depression, that prevents them from carrying on their duties competently. We will deal with what other avenues are open to an impaired lawyer at a later date. At this point, simply know that if the lawyer's abilities are materially impaired, withdrawal is required. There are also additional circumstances in which Rule 116b permits the lawyer to withdraw. We have already discussed permissive withdrawal when the lawyer thinks the client is a fraudster or other bad actor. But Rule 1.16b also permits the lawyer to withdraw when the client fails to fulfill his responsibilities. For example, the client has failed to pay his bill. It permits the lawyer to withdraw for any reason or no reason when withdrawal can be accomplished without prejudice to the client. For example, if the lawyer has just accepted Case A and then is presented with Case B, a much bigger, more time-consuming case, the lawyer should be able to withdraw from Case A without prejudicing the client, as the representation has only just begun. Note that the various reasons listed in Rule 1.16b for permissive withdrawal are alternatives. The attorney may withdraw if there is no material adverse effect on the client, or if the client persists in a course of conduct the lawyer reasonably believes is fraudulent, whether or not the withdrawal may have an adverse effect on the client. The attorney must be aware that when representing a client in court, any withdrawal must be done in accordance with court rules. For example, an attorney may need the court's permission to withdraw if a motion is pending or the trial is scheduled. Thus, the attorney may need to file a motion to withdraw, giving his reasons to the court and notifying the client. Note that the rule requires the attorney to continue with the representation if ordered by the court to do so. In other situations, an attorney may simply be able to file a notice of withdrawal, again notifying the client, opposing parties, and the court. Here it is important that the attorney consult the rules of the court. Finally, whenever the attorney withdraws, she is obligated to assist the client with the transition, including giving the client reasonable notice, allowing the client time to find other counsel, providing the client with his papers, and refunding any advanced payment or unearned fee. Note that the attorney may retain papers related to the client only as permitted by other law. While the rules define the attorney's and the client's rights and obligations to one another, discipline is not typically the constraining or defining process for these issues. This is more typically done by court rulings in the context of specific cases. For example, the trial court will decide whether appointed defense counsel will be released because the criminal defendant is dissatisfied or wants to represent himself. The trial court will decide whether to grant a motion to withdraw when the attorney must file such a motion. Another example arises in appellate litigation dealing with claims of ineffective assistance of counsel by criminal defense counsel. In the case of Anders v. California, the attorney appointed to handle the client's criminal appeal did not see any legal issues to raise. The client wanted certain issues raised. The court ruled that the attorney did not need to raise the issues the client wanted raised. This was a means rather than an objective of the representation. Thus, it was the lawyer's right to decide the best means of pursuing the appeal. However, the court ruled that the attorney did have to file a brief and at a minimum outline possible issues for appeal. Such an approach is now called filing an Anders brief. In criminal cases, it is not unusual for the appointed attorney to see particular approach as the wisest strategy and the client to want different issues raised or strategies tried. In criminal cases, it is not unusual for the appointed attorney to see a particular approach as the wisest strategy and the client to want different issues raised or strategies tried. The lawyer's failure to raise an issue or pursue a particular strategy will not be grounds for reversal for ineffective assistance of counsel, where there may have been a strategic reason for the lawyer's choice. Under the case of Strickland v. Washington, an attorney's alleged errors in the representation are grounds for reversal only if there is a reasonable possibility that, absent those errors, the fact finder would have had reasonable doubt about guilt. Courts are highly deferential to strategies that the lawyer selects. This is the end of this lecture. In preparing for class, please take the quiz posted on TWEN and think through the problems also posted on TWEN.